I just want you to know in this episode, we're going to speak about something controversial, our borders and how important they are. No, I'm not going to talk about immigration, but cross-border financial issues between the United States and other countries. You know, in a lot of ways, these type of border issues are really just about cooperation with other people in our CFTC space that are trying to really do the same thing we are, which is foster open, transparent, competitive, and financially sound markets. Cooperation is critical given the global nature of the markets we watch. And this really gets down to one word, deference. And what the heck does that mean? It means it's time for an expert. Welcome to CFTC Talks. I'm your host, Andy Bush. Just a quick reminder, as always, there's a disclaimer at the end of the show that's important for you to hear. In this episode, we're going to speak to Eric Pan. Now, Eric is the Director of the Office of International Affairs at the CFTC. Mr. Pan's office advises the Commission regarding international regulatory initiatives. He provides guidance regarding the international issues raised in Commission matters and represents the Commission in international groups such as the International Organization of Security Commissions, IOSCO. We're going to cover a lot of ground on what his background is, his career, lessons he's learned, what he does for the agency, and important international issues. Eric, welcome to CFTC Talks.
Great. Thank you for having me.
Before we get to what you do for the agency, I'd like to spend a little bit of time talking about your career in education because, quite frankly, it's pretty impressive. Now, you have an AB in economics from Harvard, a JD from Harvard, a master's in European and international politics from the University of Edinburgh, and from 2011 to 2015, you worked in the SEC's Office of International Affairs. So you have a ton of international experience, both from an education standpoint and a professional standpoint. How did you get into this space in the first place, and what are your keys to success in it?
So it all began actually when I left law school. I actually spent 2 years living in the United Kingdom. I was a law professor in the UK at Warwick University and a fellow at Cambridge. And actually at the time, the European Commission was coming out with their very first set of reforms, something called the Financial Services Action Plan. And as a young academic, I had studied that.
Oh, my God.
Later on, I went into private practice in Washington, D.C. I had a number of clients who were involved in international financial markets. So really, my work here at the CFTC is really a culmination after a number of years of studying, writing, practicing law in the area.
Wow, that's impressive. I'm laughing to myself because every time I talk to somebody within this agency, I find out more about their background, and it's just like, wow. But let's do a little bit of backgrounder here to start to set up the key international issues that we're going to talk about. So, ladies and gentlemen, just give me a minute here because leading up to the financial crisis, many of the OTC derivatives were not collateralized or backed by reserves or hedged. That was part of the issue. So many of these markets were pretty complex and interconnected and lacked transparency. On July 2010, Dodd-Frank was enacted. Now, Title VII of Dodd-Frank addresses some of these problems by really 4 big changes. They required the clearing of standardized OTC derivatives through central counterparties. They required trading of these on exchanges and platforms. They required regular data reporting, and they also required OTC derivative contracts not centrally cleared to have higher capital requirements. All right, so that's a big end of the setup, Eric. Now, we did that here, but outside the country, what was going on? I mean, it wasn't quite at the same place in the calendar or however you want to put it. It seems like the U.S. jumped forward before anybody else did.
So absolutely right. The Dodd-Frank was a response to the financial crisis. At the same time, even before Dodd-Frank, there was an agreement by something called the G20, the group of 20 major financial economies, where in Pittsburgh in 2009, these same basic reforms were agreed to at an international level. So everybody was starting at the same place. And you're absolutely right, Andy, that the CFTC was first. We're the largest derivatives market. We actually wrote many of the rules way before other jurisdictions. Mm-hmm. And even today, only now are some of the other jurisdictions finally getting their rules in place. MiFID II, which is the European legislation, is just coming into force in January. So everybody's been moving at different paces, and I think that's one of the challenges in the international dimension.
Yeah, I think that to me, that's what, coming here as kind of fresh eyes from the private sector myself. It's just astonishing, like how the U.S. reacted very strongly to the financial crisis. Europe was a little bit slower to react because it wasn't the epicenter. The United States clearly was, but Europe was impacted. So they eventually got around to this. And I think that takes us up to kind of where we're back right now on these international issues. So let's pull back and ask the 10,000-foot view on cross-border issues. What is going on? What are the key things that you are spending your time on?
So the key thing for the listener to know is there was already a global market. By 2009, there was a huge cross-border market already existing. So what we were trying to do was simultaneously around the world put in a set of laws to govern this huge international market. And when you have people doing it at different times and in different ways, you are naturally going to create regulatory differences, possibly conflicts, and this would disrupt this cross-border market. So our main challenge in international affairs is how do we make sure the reforms are put into place, but done in a way that we don't fragment the market or cause other disruptions to what the market's trying to do internationally?
Yeah, I think that's really important. I mean, and a lot of times when we talk about these cross-border issues, people are like, well, why, what's the big deal? Well, it is a big deal because if you develop all these different little pockets with different rules, it puts costs on the people that are trying to use those markets and eventually puts costs back onto the consumers because if you're trying to hedge like grain prices like a farmer, and I'm not saying that's necessarily the case, but if you have different prices in different places in the world, then it makes it a mess. So we want to make this, like we said at the beginning, efficient, moving well, markets that work for everyone. So let's get to the question that I talked about at the very beginning and our word. What's everyone trying to achieve with this word deference?
So the notion is that if everybody is trying to regulate their own markets, so the CFTC is responsible for the U.S. market, we have European authorities responsible for the European markets, and if you have businesses, firms that are operating in both of these places, who should regulate these firms? Deference, the concept of deference is everyone should be responsible for their home market, but to the extent that they're regulating firms that are also doing business in other jurisdictions, that we should defer to the regulatory authorities of those other jurisdictions.
Now, that's a key concept, right? It's basically saying, hey, we trust you guys, right? We cooperate and we say, we look at your rules, they're similar to ours. Let's just defer or allow your rules to be in place so that we don't have this friction between the two borders. Is that about right?
That's absolutely right. We want to make sure that we don't have duplicative rules, we don't have conflicting rules. We, the regulatory community, all share the common goal of having robust regulations that brings into effect these reforms. But we want to do it in a way that doesn't have extreme compliance costs or require firms and market participants to try to contort themselves to try to meet different requirements that at the end of the day are all trying to achieve the same outcome.
Yeah, and I think that's a key word, their outcome. So it's more outcomes-based than prescriptive, meaning instead of saying you have to follow A, B, C, D, subsection A, 3, 1, that stuff. It's more like, well, what is actually happening with the rules? Like, are we getting what we want? And if that's the case, then let's do that. Does that make sense?
That's absolutely correct.
Let's talk some international big stuff here. CFTC Chairman Giancarlo and European Commission Vice President Dombrovskis announced an equivalence decision on margin and common approach to trading platform equivalence. Why is this so important? What was the big deal here, Eric?
So this is a really significant announcement. So first, Europe and the United States are by far the two largest markets in the world when you talk about OTC derivatives.
Okay.
So if the U.S. and Europe can't work together, then right there you have a major problem in the global markets. Second is, these are very complex regulatory areas. You mentioned the basic reforms. We're talking about margin requirements. We're talking about a trading requirement. Mm-hmm. And this announcement is us putting deference in action.
Oh, okay.
Okay, we are basically saying we have, through cooperating together, through working together, even though we have different laws in place, we have Dodd-Frank in the United States, they have something called EMIR and MiFID. we can look at the outcomes, we can get comfortable with each other, we can understand what we're both trying to do, and as a result, we can come to an understanding to defer to one another. And equivalence is merely a legal term to refer to a form of deference. So this is why it's significant, because it shows it's a major success. It shows that we can solve a very practical issue, and for market participants, this is a huge win for them in terms of being able to continue to operate across the Atlantic.
Yeah, and I think that's what's so important here is that regardless of the headlines that you hear and everything that's going on in the world, all these bad things, there is good things happening. There are things where smart people are getting together and they're saying, hey, let's work this out, right? I mean, again, I'm dumbing it down a little bit, but I think that's what's encouraging when you see government. Myself personally, before I came in, I was very skeptical of what was going to happen when I came to work at this agency. But I got to tell you, that's one of the biggest surprises to me is not only that there are some really smart people here, much smarter than me, but really the good work that gets done that nobody hears about.
Yes. I mean, we're doing this not because we're trying to weaken regulation. That's a very important point, is that this isn't about lowering standards. This is about saying we agree to high standards, but now we need to talk about how they're being implemented, how they work in practice. And I think for regulators to be able to work in a very practical, pragmatic way is critical. And this announcement that Chairman Giancarlo and Vice President Dombrovskis has made is, I think, the latest example of how at least the CFTC and the European Commission are able to work together.
Yeah, that's great. Well, okay, fair warning to our audience. We're going to get a little bit deep in the weeds here, but it's important. Let's talk about central counterparties, or CCPs. What is the EU trying to do with their supervision of these key financial market utilities?
So CCPs have become incredibly important ever since 2009. The G20 leaders, as well as in Dodd-Frank, had put in place a mandatory clearing requirement for a number of OTC derivatives.
Right.
And so that's really made CCPs much larger, getting a lot more business.
Well, ladies and gentlemen, let me just stop Eric there for a second because I want to hit this point. In the meltdown in 2008, right, one of the things that the regulators and the Fed and a lot of other people struggled with when it came to Lehman was their OTC derivative book, right? We didn't know what it was. People didn't understand it to some extent. What Dodd-Frank tried to attempt to do was to make sure that never happened again. And by doing that, they said, well, hey, all these type of contracts where they're kind of floating out there, no one really regulated them, let's put them all in an area where we can see them and understand them so that if something came up like this again, we wouldn't be in the dark.
Right.
Okay.
Exactly. Right. And CCPs are meant to be a way of managing risk, right? So that's why the G20 leaders and Congress, later in Dodd-Frank, believed that it was important to encourage central clearing.
Right.
So now we're in 2017, and these CCPs, there are CCPs that are operating in the United States, in Europe, that have significant business, and they're serving clients around the world. And in the European Union right now, they're worried about what happens to these CCPs after Brexit, and Brexit being the UK's decision to leave the EU. Some of these CCPs are located in the UK. And so today, they're part of the European Union. Tomorrow, they may not be. And so the European Union, the rest of the European Union, outside of the UK, is putting forward a proposal that would allow them to supervise these CCPs in a new way or require them to move their operations onto the continent. This is a very bold move. It's a very substantial change to how Europe has done supervision. But the reason why we at the CFTC care is, of course, their treatment of CCPs in London also means that this is how they may treat CCPs in the United States.
Oh my gosh, okay.
And we are watching this very carefully because we have concerns that legitimate concerns in Europe about what happens in London may not be legitimate concerns about what happens in the United States. CCPs in the United States that are supervised by us, the CFTC, And we want to work with the Europeans to try to find a way of ensuring that their new supervisory approach does not create new barriers to what CCPs in the United States are doing.
Yeah, and I think too, we're talking about something really significant here. It's a change to a business practice. You're actually asking this exchange or exchanges to move from one country to another country, even though the contracts that they are executing, maybe only a small portion is in Europe itself. But they're saying, well, that doesn't matter. We still want this entity here because we want to see it, or I'm not quite sure what the reasons are, but I think that's important. I also think there were some examples. I think Japan did something similar to this. Am I right? And that caused some dislocations and fragmentations of prices as well. So we actually have an example of something that didn't work very well by somebody requiring companies to physically be in a certain spot.
That's right. I mean, CCPs work because they have a number of members who can net their exposures with one another through the central counterparty. Any type of effort to relocate or ring-fence a CCP undermines the very benefit of having a CCP to begin with. And so this is not only bad for U.S. members and U.S. CCPs that may be facing this, it's also not to Europe's advantage either. This is harmful also to the European markets. And I think we have a collective interest, European regulators, the CFTC, to make sure that all of our markets are strong and robust. So we really think that we hope very much that the European Union will think very carefully about this. We understand that they have many objectives that they're trying to achieve, but we want them to be cognizant of what are also some of the dangers, what are some of the things that they need to watch out for.
Well, hopefully the announcement on equivalence is a great example of the cooperation that maybe we can use that as a framework going forward so that we can come to some conclusion without creating dislocations to the market. All right, before I let you go, one more question. How does the CFTC engage with groups like FSB and IOSCO?
So again, starting back to 2009 with the G20 reforms, there is so much work happening at the international level. And that means through international bodies like the Financial Stability Board, like the International Organization of Securities Commissions. For us, the CFTC, especially since so much of our market is a cross-border market, it is critical that we have a strong voice in these bodies. And what I mean by a strong voice is we need to make sure the CFTC viewpoint, the position of our commission, are well represented in these international discussions. If we were to stand back and let the international bodies go ahead without our meaningful input, there's a good chance that some of the international standards that are developed, some of the positions, may actually be contrary to what we think is the right regulatory approach. So it's very important that we be part of that conversation. And, again, part of my job as the Director of International Affairs is to make sure that we have maximum input and influence in these discussions.
Eric Pan, CFTC Director of the Office of International Affairs, thanks for coming on the show today.
Well, I really appreciate it. Thank you very much.
That's a wrap for me. Thanks for listening. We'll be back next week with more great guests. I'm Andy Bush. This has been CFTC Talks. But wait, there's more. Disclaimer time! The CFTC is providing this information as a public service and is neither a legal interpretation nor a statement of CFTC policy. Reference to any specific product, service, trademark, manufacturer, or service provider does not constitute an endorsement or recommendation by the CFTC. The CFTC is not liable to any consumer or third party for any direct, indirect, incidental, consequential, special, or exemplary damages or lost profit related to the use of the information provided or referenced in the podcast. Selection of guests on the podcast does not imply an endorsement of any particular individual or entity. Many individuals and entities provided similar services to those of the guests. The views and opinions expressed by the guest in the podcast are their own and not specifically endorsed by the CFTC. Moreover, the information provided in this podcast should not be construed as investment advice. Consumers should rely on their own inquiries as to the accuracy and relevance of the information incorporated and referenced in this podcast and assume the entire risk related to its use. The CFTC is providing this interpretation of market trends solely to inform the public of a framework for projecting future outcomes under different scenarios. If you have any questions concerning the meaning or application of a particular law or rule administered by the CFTC, please consult with an attorney.